Hello, everyone. This is Gail Pendleton. I'm Executive Director of Assista Immigration Assistance, and with me today I have our Senior Counsel for Providing Services to OVW Grantees, Amy Chen. So what we are going to do today, and hopefully at the end of this day, you will be able to apply best practices for requests for evidence and denial, prevention, and response, understand or be able at least to identify relevant USCIS policies and practices, and discuss the expected challenges to relief with your survivors and what that means for your work. So we're going to review first the difference between an evidentiary standard and the evidentiary burden. The burden, and there are two different concepts generally in the law, and specifically in this context, the burden of proof for VAWA self-petitioners and U visa applicants and T visa applicants is preponderance of the evidence. And that generally under case law means that the adjudicator thinks that it's more likely than not, 51%, that you have made your case for relief. The standard of proof is the kinds of evidence that you can supply to meet that burden of proof. And the reason we're covering this is that we think many people get confused when they hear the any credible evidence standard. That's the kind of evidence that you can supply to meet the preponderance burden of proof. In general, in the immigration system, they prefer what's called primary evidence, which I would summarize as being evidence from systems that they view as credible. When you can't get that, they will let you provide secondary evidence. But as you know, in this area, Congress dictated a special flexible evidentiary definition, the any credible evidence standard. And that's because, as you'll see if you read some of the Immigration Services memos about this, is because they understood that abusers often control the documents that a person would normally have, which are the typical primary evidence documents that the government would want to see in order to approve a case. I just covered this. So, I'm going to come back to this later. So again, remember that the kinds of evidence you can supply is any kind of credible evidence, but you still have to meet the preponderance of evidence burden of proof. So that doesn't mean that you should assume that you can only supply one document and that they're going to view that as enough. And the way I've translated over the years their preferences in evidence in the context of the any credible evidence standard is that for a piece of evidence to be credible to them and therefore meet that any credible evidence standard, you have to show that it's the best evidence you can get. And the way that you show it's the best evidence you can get is you show that you couldn't get this primary evidence or this secondary evidence, and therefore you're supplying this evidence which meets the preponderance burden of proof, and you articulate why it's credible. And there'll be, I think we may have shared with you a little practice pointer I wrote a while back after doing many TAs on this, and if not, we can share you the link that kind of runs through how that will work in different situations and how you argue the best evidence before you supply the any credible evidence. So this is the fundamental memo where the Immigration Service, I think at the time it was INS, implemented, or might have just turned into CIS, implemented the any credible evidence standard. It's by a officer there named Virtue, which is why we call it the Virtue Memo. And it mainly addressed other issues, so you can't really tell from the title that it's about any credible evidence. Back then, you still had to show extreme hardship, and I think it might have addressed that. But it does do a good job of articulating how this flexible standard applies in the context of survivors and why it's important. And again, it reiterates that abusers often control the evidence, but it's going to be an individualized evaluation of whether your particular survivors should be able to obtain that evidence, and if they can't, what other evidence is found credible based on the whole totality of the circumstances and the context of your survivor's experience. Now, this reference to internal credibility is actually a reference to basic case law, and I believe it arrives out of the asylum context, which is there are various checks for credibility. There's internal credibility, and this is where it's really important for you to go back and look at any other applications that may have been filed for your client, because that's the internal credibility check. Not only within your own documents, like is your survivor saying something in her declaration, even if it's about dates and locations and things that don't seem like they're really that important to the case. If there are discrepancies between that and other documents in your file, you're going to need to explain them ahead of time. The other internal credibility check you want to do is checking, once you've done that, check that internal credibility against any other files that were filed for. And you'll often find discrepancies. It may be in minor things again, but don't assume those won't matter to them. So I call it the heading it off at the pass approach. I think you need to literally flag every discrepancy and explain up front in your roadmap cover letter, which we're going to come to later, why those discrepancies exist. Because then you're kind of diminishing their questions ahead of time. You're showing your good faith effort and the good faith effort on the part of your client to provide credible evidence, and you don't give them the opportunity to do a request for evidence back at you on these discrepancies.
All right, thank you, Gail. So the reason why we thought it was really important to start off our discussion today about RFEs and NOIDs with some discussion of the any credible evidence standard is because we're seeing through technical assistance, through discussions with practitioners such as you guys, that there are often issues in RFEs and NOIDs that are arising because either people are submitting evidence that does have inconsistencies and USCIS is questioning the credibility of that evidence, or where USCIS is not properly applying the any credible evidence standard. So this is one of the most common issues that we see through technical assistance requests, and we're going to be talking a little later on about some of the other common issues that we see in the U and VAWA context. But right now, we'd like to discuss some of the new RFE and NOID guidance that has come from USCIS and that I'm sure many of you guys have been hearing about and thinking about over the last couple of months. It is a new policy memo issued by USCIS in July that just went into effect last month. A copy of it is in the Files section to the right of your screen. So if you haven't read this already, we encourage you to do so. And there's also a Q&A from USCIS that came from their recent stakeholder meeting that addresses some additional questions that came out of this memo's publication. And the reason why this RFE memo is making a lot of waves right now is because it represents a bit of a change in the way USCIS has treated or has issued RFEs and NOIDs in the past. So previously, there was another old policy memo that said that while USCIS may deny cases where the applicant is statutorily ineligible for relief, such as if they filed a family petition for their cousin, for example, right, where there's no statutory basis for that petition, then USCIS could have denied that petition without an RFE and without a NOID. But generally speaking, USCIS did issue an RFE or a NOID in cases where perhaps there was some evidence missing, but the person didn't seem to be statutorily ineligible. In the new RFE guidance that was issued in July, adjudicators now have full discretion to deny applications without an RFE and a NOID or a NOID where there's no statutory basis, so that's the same as the old policy. But the difference is that they can now issue a denial where the application lacked sufficient initial evidence, right? And so the examples that they have given have been cases where somebody was applying for a waiver and didn't include supporting evidence. Also, if somebody was applying for adjustment of status and was required to provide the affidavit of support but didn't do so. Right? So these are the examples that USCIS has given of required initial evidence, of the lack of required initial evidence being grounds for a denial without an RFE or a NOID. And USCIS's rationale for this policy change has been to prevent frivolous and placeholder filings. The issue was that in light of the adjudication delays with USCIS, there were some practitioners and some applicants who were submitting skeletal filings to try to get themselves in line with the idea that they would be supplementing later, perhaps at the issuance of an RFE or potentially before. But USCIS is trying to discourage this practice, and they want people to be filing complete applications from the get-go. And they have said the purpose of this guidance is not to penalize innocent mistakes, right? But what does that mean? How do they know when something, or what do they consider to be an innocent mistake versus an incomplete filing that would justify a denial without an RFE? According to the stakeholder meeting, the examples that they gave for innocent mistakes included things like if it looks like maybe just one page of something, like one page of a full copy of a passport got stuck in the copier machine or something like that, where they wouldn't penalize applicants for some kind of simple, innocent clerical mistake like that. So theoretically, you can still expect to get RFEs or NOIDs where it is a mistake that USCIS considers to be innocent. And it's also important just to note that this guidance does not apply to DACA and asylum applications. Okay? Right. So how does this change how we file applications now? So the thing is, it doesn't actually change what everybody was supposed to be filing with these applications, right? The requirements for the application packets remains the same. What has changed is what USCIS will do about it if your application packet is incomplete. And so to make sure that your application isn't rejected or denied for lack of sufficient initial evidence, the best thing to do is to read the form instructions line by line, because the form instructions are the official instructions from USCIS on what you must include with any given application. And they're the most complete guidance that you're going to get. And so reading the form instructions, which do change pretty frequently, is always a good idea. And you always want to check the regulations as well. The other recent development is that after this RFE memo was issued, USCIS developed a set of checklists. And there is a checklist for almost every single type of form that's available at uscis.gov. So if you go to the web page for each type of form, there most likely is going to be a little tab under there that says checklist. And the checklist, in theory, has each piece of evidence that must be submitted with the packet in order for the packet to be considered compliant with the requirement that you have all of the required initial evidence. The problem is that the checklists, aren't a replacement for the form instructions or the regulations or the statutes. So to the extent that the checklists are incomplete, you can't rely solely on these checklists. So one example is this little example that we have at the bottom of the slide is for VAWAs. But if you look at the checklist for the 918 for U non-immigrant status, you'll see that there's a list of various documents that you should be submitting, like the certification and things like that. But you'll also notice that they don't have the 918 as a requirement in the checklist. But of course, if you're filing a U visa application, you absolutely must include the Form I-918, right? And so, I would recommend using the checklist as your, as as one of the many tools that you have at your disposal. You want to make sure that if it's on the checklist, that it's in your packet. But the checklist is not the end-all and be-all. You have to make sure that you're reading the instructions, checking the regulations, and submitting all of the things that you should be submitting with these packets.
So I'm curious, Amy, have you had any TA where people have been denied in this kind of situation? And if any of you out there have, please chat us, because this is a general rule, right, a general change, and it seems to me that especially U's and VAWAs, which have this prima facie standard that comes in at various points, is this just basically a de facto elimination of the prima facie standard? So I'm particularly curious if some of you are getting these kickbacks and you're trying to get prima facie notices on either U visa cases or VAWA cases, because we would want to fight back on that. Because the standard for that is supposed to be a statement of facts that, if supported, would lead to approval. That's definitely not what they're saying here, it sounds like.
Absolutely. And this change, I think, it only went into effect in September, right? And so we're relatively early on in the implementation of this policy memo. So as Gail said, if you guys are seeing in your practice that you're getting denials that seem incorrect, please do write into us. We definitely want to hear about that and work with you on that. I haven't seen those TAs yet, but it's probably only a matter of time.
Right. Okay. Yeah, because it seems like they're going to be, and I can move the slides myself. It seems like there's some really big open questions, right, because of the certification, and often the certification will expire before people have done all the research they need to do a full I-192. And I would argue that you shouldn't have to do a full I-192 to apply to, survive this scrutiny, but we don't know yet if that's going to be true, right? Did anyone ask that, do you know, Amy, whether on this call?
No, or if they did ask, it wasn't answered, but I don't remember hearing that question. Okay,
so that to me is where the rubber's going to hit the road on this. So keep your eyes out there if you're seeing it. Oh, maybe, Amy, you could read these responses while I move forward on this. Okay, so while she reads that, I'm going to set this up for a poll. This is a hypothetical. Your client is a victim of domestic violence who has a son who will turn 21 in November, next month. She remembers speaking to an immigration official when she crossed the border, but she doesn't remember what happened. How would you file the U visa? And now we're going to put up a poll, and I think, Alicia, you're going to make sure this works. Excellent, thank you. So while they do that, do you know, Amy, Maria asked, is the memo retroactive, on data filing for all those cases that have been pending for like 2 years? Are they going to suddenly open them up and deny them?
Right. So I'm going to try to put some answers into the chat box as we go, and we can address them out loud as well. The policy memo applies to applications received after 9/11/2018.
Oh, good.
So it should not be retroactive to applications that were submitted before that or received before that.
Thank you. And now I'm going to turn this over to you to facilitate the poll and discussion.
Okay. All right, let's just give it another couple of seconds here. Okay, so let's go ahead and close the poll. It looks like the answers are pretty consistent here. So the one thing I would say is that there isn't necessarily a strict right or wrong answer for this poll as well as many others, right? I mean, there's typically a bit of strategy consideration, and also there could be some particular factual issues in your case that push you one way or another. So in this case, it looks like most people are saying that they would file the 918 with the 192, saying that they might be supplementing or amending the 192 later on. This is certainly one option, and even based on the policy memo, the requirement for the 192 is if you think you're inadmissible, right? You must be filing a 192. You know that she crossed the border. It sounds like she entered without inspection, and so you would have to file the 192 regardless. So you would be filing that, and you're saying that you might be supplementing or amending later on if you find additional grounds of inadmissibility. And that approach might work in this situation. I think my analysis might be a little bit different if you were looking at unknown or unclear criminal history that might give rise to a CIMT ground of inadmissibility. So there could be some situations where you might want to have more complete information, as in the last option, waiting to file until you have all the information before you file the application. But there's isn't there a reason not to do that, Amy? In terms of waiting not to file until you have all the information? Yeah. Certainly. Yeah. I mean, especially in the U context, but also you could easily see this in other contexts as well. I mean, there are many reasons. One is that you could have deadline problems. You could have a 918B certification that's about to expire. You could have age-out problems if your principal is turning 21, if any of the derivatives are turning 21 or 18, if it's a sibling. And you could also certainly have issues related to the amount of time that it's taking USCIS to adjudicate U visas. Right? That's the whole reason why people have gotten into the practice of filing, skeletal or placeholder applications, that it's taking so many years for these applications to be approved that you want to get your client a place in line. Okay. And so, yeah. Just before we move on, I wanted to mention the kitchen sink option here. For any of you who have been doing I-192s that say, if you find any other ground of inadmissibility, please grant a waiver based on our other public interest arguments. I'm the one who suggested it, and it was a bad idea, because what we discovered is that they are not able to figure out from your facts what the grounds of inadmissibility are that's triggered. So it's better for you to literally cite those grounds and not expect them to be able to figure it out from your facts. So just a little footnote there. You ready to move on, Amy? Just a note on what you just said, Gail. It's also that kind of issue where you're asking for you're making a blanket request for a waiver also does not work for consular processing. If you have derivatives or even a principal overseas who needs the consular process, in order for DOS to understand that a particular ground has been waived, the full citation down to the last subsection must be in their system as having been waived. And so if you're just putting in the catch-all waiver request, that's not going to work. Yeah, so what Amy's referring to, for those of you who've been doing these cases for a while, is that you never know what grounds they've actually waived, right? They never, when they grant your U visa, they don't tell you what grounds they waived, but they do put them in their system, so when people travel, the Department of State does know what they are. And we've literally been asking them for 20 years to figure out how you can get access to them. But that has not worked so far. On the list. Okay, shall we move on, Amy? Yes. Okay, I don't know how to get rid of this polling thing, Alicia. Okay. Did I miss something? We didn't do this, right? This is okay. So, I think you're doing these practice pointers, Amy. Sure. So when you are filing the applications, then as we said earlier, please review the instructions. The form instructions are really your best friend in this process. And then, review the guidance that you've gotten from USCIS, and then review the application to make sure all the pieces are there. Sometimes these applications are really substantial with a lot of pages, and it's very easy to overlook something simple. But if you want to minimize your chances of getting a denial without an RFE, then this is really key now, even more so than before. And then, obviously, always be aware of deadlines. So for VAWA, it's 2 years post-divorce, and then you also want to keep track of potential age-outs for derivatives. And then for U visas, the date issues as we discussed earlier. Which is why the hypo mattered, because the child was going to age out in next month, I think.
So you had a choice to make.
That might be in a later hypo. I don't think it was in the one that we just did. But if you had a derivative who was going to age out, then you would certainly need to file before they were going to age out. And then the other point is that this RFE memo was issued in July, and then around the same time we also got a new memo from USCIS about the issuance of NTAs, of notices to appear, for people whose applications had been denied and who were removable, who had no lawful status. That memo is a little bit more detailed than that, but for purposes of our discussion today, the thing to be aware of is that if the application is denied, then your client runs the risk of being placed into removal proceedings, being issued an NTA. The NTA memo is currently not in effect for humanitarian applications. We have asked USCIS for clarification on what they mean by humanitarian applications, but we haven't gotten any clarity on that thus far. Our hope is that humanitarian applications means U's, T's, and VAWAs, and hopefully special immigrant status as well, but special immigrant juvenile status as well. But we haven't gotten confirmation of that from USCIS, so we don't actually know. So in light of all of that, it's really critical to advise clients when you're filing about what could happen if the case is denied.
Right, because up until now, they've used their discretion to say that in the vast majority of cases they won't do that because they know it will have a huge chilling effect. So if you've been giving that advice to your clients, I think you need to rethink that at this point. We don't know if they're going to do it, but it's now a possibility. Okay, some common requests for evidence and how we suggest you respond to them. These are based on our 20-plus years of experience doing interventions with the Vermont Service Center and what they've told us. So what they have told us over the years is, this is the heads of the unit, that if you're getting boilerplate RFEs, basically requests for evidence that looks like they just cut and pasted the checklist that Amy's talking about and didn't actually look at your evidence, they have said that they have their own internal rule that no adjudicator is supposed to be sending those out. And you should immediately forward that to the email hotline and tell us, put in your subject line, supervisor review of boilerplate RFE. Doesn't mean you don't have to reply. I think a common theme you're going to hear from is this: always reply timely. It's just what you're going to say may be different in the context. The rule that the heads of the unit and headquarters agree is that when they send out a request for evidence, they have to tell you what's missing in your evidence that you supplied, and they're supposed to discuss all of the evidence you supply and explain why it's not credible or put together it's insufficient. So Deepa, you're getting I-912 denial simply stating that the evidence is insufficient. I would say that's not exactly a boilerplate, but that is definitely something that violates these rules. So again, we're going to come back to this again and again, and it's probably worth reminding you, is that the system, we actually, because we worked on these laws at the very beginning and had very good relationships with the folks at INS at the time, we actually have worked closely with them to resolve problems over the years. So when we ask you to send a problem to the email supervisor system, we ask that you CC Amy. It used to be me and Cecilia. Now it's Amy, our fabulous OVW person. And then we can track what their replies are and raise any inadequate or inappropriate replies to the heads of the unit and to headquarters and to the Ombuds office, which will probably also suggest that you do. So this would be an example of don't wait and don't assume that they're right. Contact us and we'll help you figure out what your next step is and then what you should do to reply timely to them. Can I let you, Amy, read the rest of these chats while I move along?
Sure. I will note that everybody is having the same issue where they're emailing the Vermont Service Center hotline and not receiving replies. I have not heard that there has been an official decision by Vermont to stop replying to hotline inquiries. So it's a little bit hard to tell if it's a backlog issue, if it's a capacity issue, or if something larger has changed here. But yeah.
A couple practice pointers on that. For us to be able to help you, it has to be an email to the hotline. The phone calls you make to the hotline, we can't use those as evidence because you don't have any evidence. So we would implore you, if you have a problem, to use the email hotline. And then what we do is we can pick some random amount of time, 2-3 weeks that they should be responding. And if they get no response, we also take those up. And that's an issue by itself for the Ombuds office. So that's worth letting us know that you're not getting any kind of reply. Again, if you CC us on your emails, we will eventually notice it, but you're probably going to have to poke us to remind us that you haven't heard anything.
Right. And the Ombudsman office can also be a really strong option in these cases where you're not able to get a response from Vermont as well. So you can take a dual-pronged approach and approach the Ombudsman office at the same time that you're asking us to follow up with USCIS as well. Yeah, and the main thing these days, I would say, worth raising with the Ombuds are going to be procedural issues like this. I would be loath to raise the subject issues as much with them, but we are still, headquarters is still very much interested in the subject problems that you're seeing, the content problems you're seeing. Okay, so documents already submitted. Sometimes, I don't think this is usually true because I think most of you are doing this now, but occasionally we'll review a TA and it'll just be like a huge pile of documents with no kind of roadmap on how the adjudicator is supposed to figure out which documents go for what eligibility requirement. Do not assume that they're going to be able to figure this out. And I know many of you have heard this before, but the picture I like to paint for you is what an adjudicator's life looks like in Vermont. They literally are in little teeny boxes in a huge room with piles and piles of files on their desk. So imagine yourself coming in with your coffee in the morning and you open up a file and it's just a pile of documents. And then you open another file that literally has a roadmap that says, this is how this client shows, she was subjected to battery, extreme cruelty, see attachments, blah, blah. I'm going to do that one first. That's easy. So that goes back to you thinking about how to make it easy for them to want to, first of all, even look at your case and then to think favorably about your case. This is where I do think those checklists are useful. We've known that are happy. We've known about them for a long time, but we've never seen them. And so I think if you can see what checklists they're going to have next to your files as you open it, I would organize your individualized bullet points in your roadmap cover letter to literally follow that checklist. So they can literally just sit there and go, check, check, check. And what you refer to, the other piece I think is really important for you to do, and I know those of you who do thousands of cases, this is hard, but the best practice is you have an index to your documents too, so that the index is organized by the eligibility requirement you're trying to show with little brief paragraphs for each document telling the adjudicator where to go in that document to find, for instance, the evidence of humiliation, degradation, whatever, as extreme cruelty, and then in those documents, literally take a highlighter to them and highlight the things you want them to read. So that all they have to do is say, okay, battery, extreme cruelty, index says I read the declaration and the corroborating declaration, I go to those declarations, I read the highlights, check, that's done. So part of what we suggest to you, if we haven't already worked with you in the past, is that you go back and look at how you're presenting your cases to make it as easy as possible for them. Now, assuming that you've done all that and the problem is really on their end, not understanding what you're supplying, then we have seen many requests for evidence that we think are beyond what they should be requiring. That you've already submitted the best evidence you can on something, and what they're asking for, in our view, violates the any credible evidence standard or the preponderance of the evidence burden. And so this is why I have this third bullet point, is talk to us first. Don't kill yourself trying to find evidence
that we don't think they should be asking for. We'll help you figure out how to argue that what you've already supplied is sufficient, and that if they would, if they were following their own memos, they would be analyzing it under the totality of the circumstances test, and finding that you had met both the burden and that all your evidence was credible. The other piece of this that you may see is that they tear apart each little piece of evidence you supply and then never look at it in totality. And we've got lots of responses from that in our past history that we can help you with also. There's a bunch of amicus briefs, basically, that we've done to the AAO in various contexts that address this kind of evidentiary concern in the context of various eligibility requirements. So here's kind of the worst case scenario is you get an RFE asking for documentation that's not material to eligibility, completely mischaracterizes the evidence you supplied, or is just factually wrong about the evidence you supply. Again, you got to reply timely. We would help you ask for supervisory review for the hotline. When we do that, by the way, we don't argue they should grant your case. We just highlight the procedural and legal irregularities so that we say, we're not telling you how to rule on this, but we want to point out that they did actually give you these documents and that these documents actually do meet the any credible evidence standard, blah, 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 and the totality of the circumstances, all that stuff. And so, again, especially in these cases, it's really important to contact us right away because we may already have like briefs or at least arguments about various things they're asking for that aren't required, and you don't need to recreate the wheel. Okay, I'm going to start this one and turn it over to you, Amy. I think we're starting to see this more often. We've only seen it a few times in the past, where the RFE comes back and seems to be alleging things that you have never heard about. You've done your due diligence with criminal background checks, your client, you've found all the prior immigration files, and they're coming up with something that you have no reason to believe is true. Tell us, Amy, what the deal is with challenging that. So the thing with these allegations is that they have to tell you what it is that they have on your client. They're not allowed to just give you an RFE that says, explain your arrest for X without telling you anything about it. And so if you get an RFE like this, we would recommend taking a look at this regulation that's cited in the second bullet point. And the point of this regulation is that it requires USCIS to tell you or to tell your client any derogatory information that is unknown to them on which USCIS is potentially going to base their decision. So it's not optional for USCIS to tell you what it is that they have on your client. And there are very, very limited exceptions to this. The exception is for classified information, and there's further language in the regulation that you guys can see about what it means for information to be classified. Essentially, generally speaking, when they are making allegations about your client's criminal history and gang affiliation, it's pretty unlikely that the information is going to be classified. The problem is that, generally speaking, USCIS doesn't have to provide the actual derogatory information. So, for example, if they're saying that they have indications that your client is a member of the gang, they have to tell you more than that, but they don't actually have to turn over the actual evidence that they have that your client is a member of a gang. But that said, they still have to give you enough evidence to give your client an opportunity to rebut this information. Right? So using this regulation is a useful tool when you're looking at this kind of problem with your RFEs. Other strategies can include FOIAs and running background checks. The thing is, generally speaking, we would recommend running FOIAs and background checks on your clients before filing the application so that you're not caught unawares about issues that could come up later. But let's say there was something that you didn't know about that's coming up on the RFE. You can try to figure out what it is by running FOIAs and criminal background checks. And some of them can be done a lot faster than others. Obviously, the USCIS ones tend to take quite a while.
but CBP ones tend to be a lot faster, for example. And then for criminal background checks, you may find that state and local checks are a lot faster than FBI background checks. So you may be able to get the information that USCIS thinks it has before your RFE deadline.
So just a few general RFE response, and this comes back to my best evidence framework. What would be the best evidence to show something? How did you try to get that? So typically, they might, in a domestic violence context, they might want to know, did you call the police? Did you go to the hospital? So it used to be that all the adjudicators were very well trained on domestic violence and understood why that didn't happen that much. Do not assume that anymore. It's, things have become very opaque, so it's a little hard to tell what kind of training many of these adjudicators have had, but I think if you look at their RFE responses, it's pretty clear a lot of them have not had much training in domestic violence, so you should assume part of your job, back to basics, is training them on the context of domestic violence. So why didn't your client call the police? Get your corroborating, DV counselor to explain why this was typical, and especially for an undocumented person whose abuser exercising power and control over, blah, blah, blah. Same with going to the hospital. Just go through the motions so that you don't have some ill-trained adjudicator coming back and asking these basic questions. So, and, if she didn't try, then you don't have to explain how you tried to get it. But if she did do it and you couldn't get it, then explain it. Like sometimes police reports for good moral character, for instance, are not available. So explain how you tried to get it. Why weren't you able to get it? So again, if you can document, that's fine. And then the final really important argument, now that you've set up that there really is nothing else you can supply that they could ask for, this is why what you are supplying is credible, and why, put it all together, it meets the preponderance burden. Okay. Oh, yeah, these are pretty basic things, like always look at both sides of what you get from the government. There may be things on the other side. Always, always, always respond on time. Even if what you're saying is, look, you're asking for all these things. You can't possibly get these in 30 days, but here's how we're trying, and here's what we've gotten so far. And by the way, if you look at the things we highlight in the attached index to documents here, what we already supplied, in the past at least, we've seen them grant, even when you haven't supplied everything. I think there's a bit of the, attorney-client good faith effort to answer their questions mojo that you get when you do that. But it's more important to answer timely than to have everything that they want. Because the worst thing is if they deny for failure to respond timely. Frankly, that's much harder to fix than they were wrong on a substantive issue. So one of the things we do with you as you're writing your emails to the hotline is help you calm down and put it in a way that's not going to offend the person on the other end. I completely get it. I mean, I can tell you that many times when I do an intervention, is someone else talking? I will literally craft my emails 3 times before I send them, because you start up ranting and then you focus down on what is it from their end that is going to make them want to do what you're asking them to do. So it's not only just being civil, it's often trying to understand where they're coming from and saying, maybe the problem was this, but really what's going on is this, and could you please help us fix it? You always want to, this is just a basic thing, whenever you're communicating with the Vermont Service Center by snail mail, you have to put a copy of the last written missive you've gotten from them on top. That's a mailroom question. And always write, VAWA unit in big red letters on your outside envelope, because you don't want this going off to some black hole at the Vermont Service Center. It will just disappear forever. We've seen that happen. I know that in the past, many of you have been able to negotiate solutions to RFE problems over the email, but that is not a formal reply. And we really need to be following the formal procedural rules these days. Again, you do not want to give them a procedural reason for denying your case. It's so much harder to fix. So always reply by snail mail timely. Doesn't mean you can't also do the email, but do not rely solely on email communication to fix anything with that. It's just not formal. Doesn't follow correct procedure. And you want to, I think you all are filing snail mail things with some sort of proof of receipt, but that's really vital because some of you may have experienced this, but it used to be they didn't work on Fridays or something like that, so that you would file something on Friday, you'd get the receipt notice that the huge building got it, but the VAWA unit would then say, oh, we didn't get it till Monday, so you didn't file timely. If you have that receipt notice, we can prove that you did file it timely. Okay, I think we're back to you, Amy. Do we want to address any of the chat before we move on?
Yeah, so a couple of things here. So Stephanie has a great tip on submitting FBI background check requests to get a response time in only 2 weeks, which is pretty remarkable. Wow. Yeah. And also there's a question in here on getting USCIS FOIA responses quicker other than to narrow your request. Well, there are not necessarily tried and true tips, but there are some things you can try. Sometimes following up with the USCIS FOIA office can be helpful, especially when they're past their deadline, because there is actually a statutory deadline for them to respond to your FOIA request. There are also some people who do FOIA litigation, and that is also an option, but obviously a bit resource intensive. So, in terms of efficiency, sometimes just following up with the FOIA office could be your first resort, and then you can take it from there. But there aren't necessarily great tactics with this. But if anybody has other tips, please do share in the chat box.
Yeah, because for those of you who are new, we have some old hands participating as well, and I think it's really helpful for those of you who are newer to learn from those who have been doing this for a long time. So keep sharing. So Amy, are you doing, I think you're doing RFE prevention, right?
Yep. Okay, all right. So obviously there are a lot of issues that can come up with RFEs, some that you might anticipate, some that you don't. But to the extent possible, obviously it's always better to do everything you can to prevent the RFE in the first place. And you'll notice that a lot of the tips that we have here are pretty self-explanatory, and some of them are very similar to the ones that we have for responding to RFEs, because ultimately I think that the underlying approach to these issues is always going to be trying to make the adjudicator's job as easy as possible and to make the adjudicator want to grant, right? And so you're trying to show the USCIS officer that this case is easy, that this case is straightforward, that they have all the information that they need to grant your case without an RFE. So going back to Gail's tips earlier about organizing the application, including a roadmap, highlighting all of the evidence that you're submitting and what it goes to, organizing your cover letter by element, so you're highlighting for the adjudicator why your client is eligible and what evidence you're already submitting to show that they are eligible. Also, inconsistencies. We get a lot of TAs for RFEs where they've identified some kind of inconsistency, whether or not it's material, right? And so going through and really combing through the affidavit and the corroborating evidence to make sure that the details are consistent with each other is really critical. And to make sure that you're addressing these inconsistencies up front. So to the extent that you have to submit documents that have inconsistencies, and there are times that you have to do this, that you're providing an explanation in your client's declaration as to why this inconsistency exists, and to explain that it's not, it shouldn't throw your client's credibility into question. Another issue that we see sometimes is that people are making statements in the cover letter and thinking that these statements in the cover letter serve as evidence for the filing. They don't. The evidence for your filing comes from the affidavits, from the corroborating documents, from your exhibits. Statements in your cover letter in and of themselves are not evidence in the case. And so if you're saying something in your cover letter about let's say it's a VAWA case and you're talking about an abusive incident. If that incident is not contained elsewhere in the application, then the officer is not going to consider that statement in your cover letter, right? Because there's no evidence that it happened. So that's just something to watch out for. The purpose of your cover letter is really to make legal arguments. It's to highlight those pieces of evidence that you're submitting, to explain why your client is eligible for the relief that they're seeking, and to identify and provide arguments and citations for the issues in your case, for the legal issues in your case.
But just remember that many of these adjudicators are not lawyers. And so when I do TA, you'll often see me saying you need to stop sounding like a lawyer because they're not going to have a clue what you're talking about. I actually think sometimes it's worth backing up and bullet pointing your arguments. You may not submit the bullet points, but at least that'll make you tease out the kind of ways of presenting this that a non-lawyer would understand. One of the things I don't think they understand very well is materiality. So we often see them combing, and I'm sure you all have seen this, combing through the declarations and finding discrepancies in like dates that are completely immaterial to the application. I think it's worth, Amy, maybe we should pull together a little brief or just like a one-pager on the case law on materiality that everyone could start using for challenging these. If any of you have already done that, I know some of you have been around a while, if you've had to argue that the discrepancies they're targeting are not material, why don't you send that to us and we can redact it and share it with everybody.
Okay.
We ready to move on? Okay.
Yes. All right. And then the same guidance that Gail talked about earlier regarding best evidence applies to preventing RFEs as well, right? And so you want to get out ahead of the ball and explain, what is the evidence that you're providing. If you're not able to provide primary and secondary evidence, if you don't have that systems evidence, explain why it's not available, what you've done to try to get it, why you haven't been able to get it, and why the evidence that you are submitting is the best that you can do and why they should accept it. Right? So these are really the same principles that apply to responding to RFEs that would apply in the prevention context as well. Right. And then the other thing that we see a lot is that people are providing general descriptions or sometimes even opinions in their affidavits. And the problem is that USCIS really wants to see nitty-gritty detail. They want to get down to, okay, so this is what you think. Why do you think that? What evidence, what specific incidents or interactions happened that make you have this opinion, right? And so sometimes we'll see affidavits for VAWA self-petitions where you're going to, jealousy, possessiveness, social isolation, and you're describing that your client says that her abuser always watched her, right? He was always watching me even when I was in the house. But it's much more convincing for USCIS if you can break it down more than that. What do you mean by he always watched you, right? So instead of saying just that, you would say he moved the sofa so that he could sit there and have a direct line of sight to the kitchen while I cooked, right? And then that might be a springboard to other detailed information, like he said that the reason why he had to have a direct line of sight while I was in the kitchen cooking was because he was afraid that I would take that opportunity to call my friends or family or the police to tell them what was happening, right? And so it's better for the credibility of your case if you can provide this kind of really, really nitty-gritty detail to explain what it is that actually happened. What are the incidents that happened? What were these specific interactions about?
That's a great example. For those of you who have been around a while, you know that the more idiosyncratic your facts, the better. Because what's in the back of their mind is they're never going to actually interview your client in except maybe at VAWA adjustment. And in terms of fraud, what they're looking for is this something someone could have gone on a website and basically copied from a website? So you know that every survivor's experience is different from every other survivor's because of the specific facts like this. And one thing I suggest is if you're like you've inherited a case or you've got an initial declaration, is look for anything that's a generalization like this. Look for anything that's an opinion, like they loved each other and they had a good marriage. That's not going to be good enough. We'll get into that in the next slide. Look for adverbs and adjectives, and in those places, see if there's a way that your clients can provide facts or that the corroborators can provide facts that will lead the person reading it to those same conclusions rather than whoever's writing it stating those conclusions. Oh, criminal history. This is yours, I believe.
Okay. So obviously sometimes our clients have their own criminal history that needs to be disclosed and addressed in their application. So as general guidelines, we recommend trying to connect the criminal history to victimization, right? So perhaps the level of trauma for your client led them to engage in certain activities, including substance abuse or potentially other things as well. You can try to corroborate this or substantiate the connection through, in addition to your client's affidavit, sometimes you can get a letter from a counselor or a therapist trying to beef up that connection to the victimization. Because ultimately, these are humanitarian forms of relief, right? These are meant to be remedial in nature. But the larger issue that we're seeing is that it's not enough to just connect the criminal history to the victimization, right? It's not enough just to make the officer feel bad for your client. You also need to show that your client has learned their lesson, that your client feels remorse for what they did, that they take responsibility for what they did, and that they've taken concrete steps to rehabilitate themselves. Essentially, that they're not going to do it again. Because you want to convince the adjudicator that they would want your client as a neighbor, that your client is going to be a positive, contributing member of the community. So, to that extent, your client's detailed declaration about what they've done to change their behavior, to make explicit statements about their remorse, about their repentance, their taking of responsibility for their conduct, and also to back that up, right? You want to corroborate it with letters from people who can speak to your client's change in behavior, their change in attitude, their change in conduct. To the extent that the letter writers know about the criminal history and can speak to your client's change, that's especially helpful. But essentially, you can't, the USCIS isn't necessarily going to take your client's word for it, right? And so you want to be sure that you can corroborate what they're saying about having taken responsibility for their actions and having changed their ways.
This is one of the things we're happy to help you think about how to articulate this. And especially if you have clients in detention, it can be very challenging, thinking about creative ways to document, you know, I've changed my life, I'm not going to, you know, help my abuser sell drugs anymore, I'm not going to drive while drunk anymore, and here's why. That's going to be, as she says, that's vital. I mean, I think it's even more important with U visas than with VAWA because of the standard, but in general, given they have so much discretion, you got to think from their perspective, is this person going to go out and commit another crime and then we're going to get blamed for it, basically, and show them how that's not going to be true. Okay. Did you have anything more you wanted to say on that, Amy?
Nope.
Okay. So I actually haven't seen a lot of our RFEs lately, but what was historically has been the biggest problem, and I think the biggest denial basis has been good faith marriage. And to be honest with you, although I think it does happen more often when they're short, or if there's otherwise not a lot of evidence. We see it all the time in different cases, and I really can't figure out, to be honest with you, with what's going on up there, because to me it looks like they're applying a heightened standard to VAWAs for good faith marriage than they are for regular family-based, which is like the opposite of what they're supposed to be doing. And because of that, we've actually literally filed 2 amicus briefs to the AAO on the problems of good faith marriage. I don't think we've won either of those cases. I think one is still pending. But it's definitely worth, we put those on our website in a Word format so you can literally cut and paste the legal arguments and apply them to your client's facts. And, you know, eventually I think we're going to have to take this higher up to get it fixed if we can't get the AAO to fix it. This goes back, however, to that preparation thing, which is going back and making sure you have this, even if it's just declarations, as much idiosyncratic factual detail about how they met, why they decided to get married, what happened when they got married, and how they decided, why she just or he decided to leave, or if not leave, file for a VAWA self-petition or a U visa. Facts, 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 gory detail, boring, 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 gory detail. Get your client to work with a domestic violence advocate to write out as much as possible, and then you can weed it down to what's the most compelling. And again, people are of many minds about this. I think it's okay for you to take a declaration that's in your client's own words and organize it by topic, and you could literally put subheaders that say, you know, battery, extreme cruelty, and then the pieces of her story on that, and you could drop a footnote saying the attorney organized this, but this is all in her own words. Which, if for those of you who don't know, if there are any words that sound like an attorney in your client's declarations, they're going to assume you wrote it and completely disregard it. So it's got to be your client's words. And this is where a domestic violence counselor corroboration can be really helpful, because they're not going to take your testimony, but they will listen to it, or they should listen to a DV counselor who says, when she says that she was afraid to sleep in the room with him at night, that meant he raped her every night. And I know this because blah, blah. So that you can have that kind of, quote, unquote, interpretation of her facts that say this is battery, extreme cruelty, or what kind of extreme cruelty is, in a corroborating declaration and not in her own declaration. Okay. So this is the big one we're seeing. If you're seeing other issues in VAWA RFEs, let us know. We've occasionally, but I think these are individual adjudicator weirdnesses and they tend to get tamped down. We've occasionally seen adjudicators clearly not understand domestic violence, like they think it has to be battery or something, but that gets fixed pretty easily by taking them to a supervisor. And I would say those are an example of do not kill yourself responding when they clearly don't understand domestic violence. We are so used to weighing in on that it's easy for us to help with that and help you respond without having to kill yourself. Did I cover this? Oh, here's the abuse. Yes, thank you. Yeah, so this first one, again, this is just, they didn't get the memo, literally, on what the evidentiary standard is for corroborating declarations in VAWA and U visas. Very early on and over again over the years that we've worked with the government, they have agreed that this witnessing the abuse firsthand is a primary evidence standard and that they can't apply that to these cases. So if you get one of those, let us know right away. That adjudicator needs a chat with the head of the unit. Again, so same things about corroborating declarations, and both backing up on good faith marriage. When we see corroborating declarations that say, like, I used to, I've known them for 5 years and I know they love each other. That's a useless corroborating declaration. You got to have the facts. You got to have the facts that show why does she think they love each other. It's not just say that's an opinion. That's not helpful to them. So go back and make your corroborating declarators write down facts that add up to the opinions that they're supplying. And again, going to counseling sessions doesn't necessarily mean that you're a victim of domestic violence, right? I mean, it's a good indication of it, but what's real, a declaration from a DV counselor that says she's come to 5 counseling sessions is not a helpful declaration. If it says she's come to 5 counseling sessions, and in those kinds of discussions, I've heard about the following kinds of abuse: degradation, which, let me explain to you, in this case was he said this, blah, 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 blah. And that's going to help corroborate the battery extreme cruelty, not the fact that she went to a bunch of sessions. And we have guidelines. I know that for some advocates, this seems like a daunting task, which is why I developed a long time ago like a one-sheeter that says, for advocates, DV advocates, not lawyer advocates, here's what you do in the first paragraph, here's what you do in the second. And so it's not a template, so it doesn't look like a boilerplate, but it helps them walk through it's stuff they already know. So it isn't really as daunting as they think it's going to be to do a corroborating declaration for you. And if you don't know already, OVW and us believe that you all should be partners. You should have a DV partner or an SA partner and a lawyer partner that to provide holistic services adequately to survivors. You can't just have a lawyer or a DV advocate applying for immigration status. You've got to be working together on these cases. I mean, for one thing, people well-trained in working with survivors of domestic violence are going to be much better than those of you who haven't been trained in getting the full story and actually understanding all the experiences that she had are a form of domestic violence and articulating what those are. And again, even those of you who do understand it, you're not going to be able to write a declaration about it, so having someone else do it would be very helpful. Yes, so this is basically, this is a bullet point of the one-sheeter I do for advocates. So if you're working with advocates or any of you, non-lawyer advocates or any of you are DV or SA advocates, you can find this on our website in the VAWA section. And there's also one for U visas on helping do declarations on harm. I think you're taking over with U visas now, Amy, is that right?
Yeah. Okay. All right, so let's start off with a little hypo. So let's say you have a derivative with a pending 918A. Her mother was a victim of DV, but the derivative was charged with a violent offense after the filing was submitted. And in the police report, there are some allegations of gang involvement. Okay? All right. So, Alicia, we could get the poll up. So people can enter their responses to the poll here. Your options are letting USCIS know right away that there's a pending criminal case, wait for an RFE to respond to it, supplement or update the application once the criminal case has been completed, or update the 918A application later to include evidence of additional equity.
I just did a training for OVW for civil and criminal court judges on immigration, and they were interested in this gang issue also. And we're not going to get into it here, but I do think on the gang issue, the facts are going to be vital in how we respond to that, which is kind of what they thought.
All right, so it looks like we've got a quorum here. So most people have said that they would update the application once the case has been completed, and then there are also some responses for the other options as well. Like one of the polls that we did earlier on, I think this is a situation where there could be more than one answer to, there could be more than one strategy in how to handle this kind of situation. And there could also be some timing considerations that might influence your strategy here as well. But if we just walk through the options a little bit, most people said that they would update the application once the case has been completed. That's certainly an option. So you can submit definitely you would submit the certified disposition after the criminal case has been completed. And most likely, if she's been charged with a violent offense, there's a pretty good chance that you're looking at a CIMT here, right? And so you're probably going to need to supplement the waiver application, the 192, to request a waiver for that CIMT, right? And you're also hopefully going to have some additional positive discretionary information and documents to submit to support the issue of remorse and responsibility and rehabilitation that we addressed earlier, right?
Okay, but Amy, you won't need a waiver unless she's convicted of it, right?
Right. So if she was convicted and it's a CIMT, then you would need to update that waiver application. If she wasn't convicted, then you would still need to submit the certified disposition, right? But you wouldn't need to request a waiver if charges were dismissed or if she was acquitted or if she wasn't convicted. And then one of the other options was, yeah.
So, but Amy, I know we're kind of going off into other issues that come up all the time, but as many of you know, even if you don't have a conviction, they'll probably come back and ask for facts behind the charge, right?
Mm-hmm. That's our next typo.
Oh, okay, good.
And then one of the other options was wait for an RFE. That's also an option, right? I mean, there's a pretty good chance that USCIS is going to know that this charge happened and that they would RFE you for it. It is an option to wait for an RFE. I think that one of the dangers, perhaps, in doing so is that things do fall through the cracks with USCIS sometimes. And if your client was convicted and needs a waiver for the CIMT, you wouldn't want that to fall through the cracks. You wouldn't want USCIS to grant the 918A for your derivative client without your having updated the application to notify them about this arrest and conviction if she was convicted.
And why not?
Because it's going to cause you a lot of problems down the road when she applies for adjustment. Because first, arguably, the 918A wasn't properly granted in the first place, because if she was inadmissible at the time of the grant and didn't get that grant waived, then she wasn't eligible for the 918A, right? So it could have been improperly granted. And it's also going to be, regardless of when you disclose it, it's going to be a negative discretionary factor for the adjustment of status. But you'll have a better argument, a much better argument, if you can show that you affirmatively disclosed and explained this issue to USCIS, that it was considered, that the ground was waived prior to the granting of the 918A.
Yeah, and I also think you may have an ethical obligation to let them know, because technically, for instance, if this existed at the time you filed and you didn't reveal it, you would be suborning perjury. And since they're not actually adjudicating it until it's after, I think in that case, there's an ongoing requirement that you give them the evidence. It's a material issue that they need to adjudicate the case.
Right. And in terms of letting USCIS know right away that there is a pending criminal case, you can do that, but for efficiency's sake, you may find that it makes more sense to wait until the case has been completed so that you can submit the documentation all at the same time and not have to be making so many additional supplemental filings. But there's not necessarily a problem with doing that. And then at some point, you would certainly want to provide evidence of her equities, right? You would want to provide evidence of the remorse and rehabilitation after this kind of event. All right, next poll. Alicia, we could pull up the next one. Great. All right, so remember that for this derivative client, in the police report, it said that there were indications of gang involvement, right? And so now you've gotten an RFE asking for this police report. Are you going to submit it, not submit it, or other?
Yeah, Amy, next time we need to have a submitted only one. Okay.
All right.
Yeah, this is another one where there's no right answer, right?
Right. I mean, as you guys know, in so many situations, there are strategy calls, right? There are judgment calls in these kinds of situations, and you don't necessarily have a black and white answer. So it looks like the consensus is submit it and explain why it's not legal or factually relevant. I mean, generally speaking, the issue with police reports is that they're almost always going to be prejudicial to your client. They will oftentimes have facts in there that are incorrect. They will oftentimes have facts in there that, even if they are correct, make your client sound pretty bad. And so oftentimes there is a disinclination to submitting these police reports. And the legal justification for not doing so is that police reports are inherently biased and unreliable, right? I mean, that's why they're not admissible as evidence, generally speaking, in court. The problem with not submitting the police report where you're getting an RFE is that USCIS could just deny the application because they're not satisfied with your response, right? They ask you for the police report and you refuse to submit it. And so there's a risk there. In any case, we would always recommend making an argument whether you submit it or not submit it. We recommend making the argument that police reports are inherently biased and unreliable. There are materials on our clearinghouse on our website walking through some of the legal arguments for USCIS to not consider police reports. But that's really a judgment call for you guys as the advocates when you're working on these cases to decide whether or not you're going to submit the police report or not.
So it came up in the chat that someone just got one of these in the AOS denial, which so I pointed out that actually that's better because we can at least raise that kind of constitutional due process problem with them doing it to the AAO. Because the problem is you can't cross-examine the police, right? That's why the record of conviction looks at things that actually happen in an adversarial context, you know. And now they're asking for all this information that we can't cross, we can't chat, we can't ask show why the police were wrong, and that's a fundamental due process problem. So, but they have said in the admissibility waiver context that because the regulations prevent the AAO from reviewing their waiver discretion, they basically have the green light, unfortunately, in my view, to do whatever they want on discretion, and there's been no holding them back. But in the AAO, in the adjustment context, we actually have seen the AAO in at least one unpublished case reverse Vermont on its exercise of discretion. So let's work with you, Melissa, on this case and get it to the AAO, and we can use all these arguments. So what the arguments Amy's talking about are arguments a bunch of people wrote up that they're now supplying in all of their D14 replies about why it's basically unconstitutional for them to be asking for this stuff for the same reasons they can't do it in the immigration court context. And, you know, it's kind of falling on deaf ears, partly because that lawyer thing I was talking about. But I do think it eventually starts to sink in, and it also kind of puts them on notice that, you know, this isn't okay with us, and eventually they're going to get challenged on this, you know, in a legal context.
Right. And I would also say that, I mean, we're talking about the use of police reports generally, but in this particular example, the police report is probably going to be exceptionally prejudicial because of the indications of gang involvement. Gang involvement in and of itself, there's no ground of inadmissibility for gang involvement, right? But it's a really significant negative discretionary factor. And so even if your client was not convicted of this charge, even if she is not actually a member of the gang, the fact that it's in the police report is probably going to cause problems for your client going forward.
Yeah, and so that's my 2 cents on the gang involvement thing too, is it's basically, and to be honest, I don't know how this survives constitutional scrutiny either, but it's basically a presumption that if you're in a gang, you're committing violent acts, because it's a violent act, you know, association is the fundamental First Amendment right. So it's not being in a gang that they can be holding against you. It's the violent acts that presumably you're committing because you're in a gang. So I think that's where the factual, to the degree that you can show that the facts don't show any kind of violent behavior by your client, that will be helpful. Because people get put in gang databases for having tattoos, you know. Anyway, I'll stop my rant on the gang thing. All right. Ready to move on?
Yeah. Okay, so I think this one's yours, right?
Okay. You want to read it and then
Sure.
we'll do it? Okay.
All right. So for discussion, your client is a victim of contempt of court, and this contempt of court arose from the abuser's violation of a protective order. This is a U visa case. Your certification says that domestic violence is the qualifying crime, but the police report and the charging documents list the statute that was violated as the state contempt of court statute. So what kind of challenges do you guys see in this? And you can respond through the chat box.
For those of you who have been around, think of this as like robbery and felonious assault. Can we move on while they're, okay. Okay. All right, so I'm going to move on because similar is not a good argument, people. You need to stop arguing similar. I'm one of the people who helped write this law, and I can tell you that similar was not meant to be a loophole for crimes that don't fit in the categories. The good news is that their own preamble to the regulation says this list of qualifying crimes is a list of categories of crimes. And if you look at the AAO didn't completely adopt that approach in an amicus we wrote to them in the context of robbery and felonious assault, but they did hear us. And what we drew the analogy to was this kind of situation. Domestic violence is any kind of crime if the facts show domestic violence. Like when I went out and trained law enforcement, the way I'd get to this is what kind of crimes do you see that you charge abusers with that aren't called domestic violence? They're myriad, and they completely depend on whether there's a qualifying relationship between the two people. So, you know, terroristic acts can be domestic violence if it's committed in a state that has that relationship defined as domestic violence. So the way you argue this is that even though it's not called that, with the facts, and this is where the police reports and the certification would be particularly helpful, it is a crime of domestic violence because, and it's fine for them to certify as domestic violence. They just need to explain that it was a domestic violence context, and they decided to charge under this particular statute because the facts showed domestic violence. So we have the whole, you can cut and paste our arguments about categories, crime categories, both for domestic violence and for other kinds of crimes. The other big ones are robbery as felonious assault, which again depends on the elements of the crime and the facts. And the one that's been emerging is notary fraud as extortion or something, another crime like that. One thing I think, again, that's right. So Sally's thing about tying all together is really helpful because what we were doing as we were trying to promote this approach with Vermont, who just was not getting it, because it was a very lawyerly type argument, was have you do literally charts where you take the elements of the crime that you're arguing fits a category next to the elements of the category, or typical category crime, and then show either that the elements are there, they don't have to be exactly the same, but you have the elements of the crime you're trying to get in the category have to at least have the elements in that category, or they have to have the elements and facts that show they meet that category. So in this case, let's go back to this. So contempt of court is probably actually easier in a CPO thing because it's probably a DV CPO, and that's actually a contempt order is actually generally considered a DV crime finding. But let's assume say it was like destruction of property, right? That isn't necessarily in the DV category, but you show whatever the elements were of destruction of property and show like a misdemeanor domestic violence and show that the facts meet domestic violence somehow. Like it's probably threat of force or use of threat of force. Again, this is where actually having more detail from police and law enforcement is going to be helpful to you because they're the ones that were there. And if you can get them down to write down the actual facts that show the element of domestic violence and that they had the relationship that qualifies them, then that will help you. Are there any questions on that? Contact us. So one practice pointer is don't assume that because they charged your client or convicted the abuser, charged the abuser or perpetrator with something that doesn't sound like it fits in a category, your client doesn't qualify. Contact us and we'll work with you through this whole category analysis for qualifying crimes. All right, I think we're at the end, are we not?
We're getting pretty close. All right.
Okay.
So next up, in the U visa context, there are times that you'll get an RFE after your client has already been placed on the wait list. USCIS says that they might do this as a quality control check, or they might do it if there's new information that comes to their attention that makes them think that your client might not be eligible. So if they do this, they'll take your case off the wait list until the RFE issue is reviewed. But if your client already has a deferred action EAD, that remains valid unless the case is denied. Okay. And then in the adjustment context, we're seeing some issues come up here regarding continued cooperation. So as you guys know, there is a requirement for continued cooperation even at adjustment for use. You can show this through a new certification, but this is not required. And so in the regs, it spells out a number of other ways that you can show that your client continued to cooperate. So you can include a statement from your client saying that they were not asked for any other assistance since the U visa was filed. And then if you have evidence that the case was closed, such as if it was already closed before you got the 918 Supplement B, there's a box on there that says, that asks the certifier to say whether or not the case is closed or ongoing, right? And so if you can show that the case was already closed at the time that you filed the U, then you should be able to satisfy the requirements that she hasn't unreasonably refused to cooperate going forward. And she shouldn't have to get into certification either.
No, and before you move on to the revisiting issues, I think a practice pointer on this is that part of your case file is ticklers for you. Is if the case hasn't been closed, to go back and like have your client call them every year and say, do you need any more help? You know, so that you have in your file evidence that not only did they not contact your client, but your client actively tried to be helpful if they didn't ask for it. Yeah. But I do actually think this is not our burden. I think they've actually misread the burden in the statute. It's just this has not been a high priority for us to challenge.
And I'm seeing a question in the chat. If somebody's RFE'd after being placed on the wait list, can USCIS take them off or not? They can. So if you're RFE'd when you're on the wait list, CIS can take the person off of the wait list until the RFE issue has been decided. Okay, and then if the RFE issue is decided in your client's favor, then they'll put them back on the wait list, and they'll resume their previous position because their place on the wait list goes by their initial filing date. So, and then the other issue that we're seeing is that negative discretionary issues are coming up at U adjustment adjudication, even if they were already addressed at the 918 stage. And so if you're seeing this, please contact us. This is something that we would be interested in working with you on. And it's not just issues of inadmissibility. It includes all kinds of issues of negative discretionary factors, where even though it was already addressed and disclosed previously prior to the U grant, it's coming up again at adjustment. And so it's something that if it's coming up, we would really appreciate it if you could let us know so that we can track the issue, see how common it is, and also work with you to see if we can help you address it.
Yeah, a couple theories we want to investigate are something like res judicata, but not exactly the same, and probably looking at other administrative law contexts, and then also some sort of equitable estoppel argument.
All right, other issues at U adjustment are continuous physical presence. Generally speaking, you want to see if you can provide different types of evidence. So, it's not all, medical records. It's a mix of, leases, financial statements, medical records, employment records, things like that. If you have big gaps, you'll want to explain that in your client's declaration. Explain why there is a big gap, why there's nothing for that period, and why what you have is credible, obviously. All right, and just very quickly, what do you do if your case is denied? So you do have some options for administrative review with USCIS, including the ones that are on the slide. But we're going to be getting into much more detail about this in our upcoming webinar on November 14th. So we look forward to seeing you then.
But meanwhile, if you need help, we're here to help you. You don't have to wait to then if you need to do it. And here's our contact information. I would encourage you, if you have an individual technical assistance question, to use that link first. I think that must take them into our new fabulous CRM, where they actually get signed up and ask questions through our database. Then aim. Okay, great. So all of you guys get OVW funding, obviously. If you're not currently registered with us, you can register through the website. You can go to the same link. There should be another link to register. If you have a new grant number, a lot of grants were renewed in the last month. We'll ask you to update your grant information in there as well before submitting your TA request. And we are asking that even if in the past you've emailed us directly to ask TA questions, that if going forward you could please submit them through our website. That just helps us to organize and systematize everything. Yeah, and assign them in a fair way. Those of you who are relatively new, we also have a YouTube channel that has many of our old webinars recordings, but you have to show your grantee to access it. So you could send, Maria's email's not on here, I see. You can send that to questions, plural, at assisttohelp.org. Questions at assisttohelp.org, and she'll connect you to that YouTube channel.
I just put that in the chat box, and I'm also going to put in a link to our webinar evaluation form. So this is going to pop up on most people's screens at the conclusion of the webinar, but if you have pop-up blockers, then the link is right there, and we would really appreciate any feedback that you have. Also, if you have any ideas on what kinds of webinars you'd like to see in the future, please let us know.
And we have time to answer questions, I think, Amy, right? So if anyone wants to stay, okay.
Yeah, we finished a little bit early, so we've got some time. So if you have any questions, put them into the chat box now, or if you have any other issues, you can submit them through the technical assistance.
Good, we've got some questions coming. Those of you who don't have questions, feel free to do the Survey Monkey and leave unless you want to hear us talk some more and answer other people's questions.
One other thing I would say about the YouTube channel for anybody who hasn't checked it out recently is that we have our OVW webinar recordings on there, but I believe we also have our private webinar recordings. Isn't that right, Gail?
Oh, good. Yeah, I think. Yeah, I mean, So and everything on our website right now is free. Because, you guys get access to everything, including the things we do for our private members. So. Right.
So, for example, one of the hot topics recently has been fee waivers and fee waiver denials, and we did a private webinar a couple of weeks ago on tips and pointers on that, so you might want to check it out. And so there's some additional content online that might be useful.
I keep seeing Leah and Lynn typing and then not seeing anything they wrote. So am I missing something? Here we are. I'll read you the question from Lynn, okay? I had a U visa that was approved for the wait list, and the approval was issued with an incorrect last name. I emailed VSC weeks ago with no response. The approval is useless because it's not the client's legal name. What should she do, Amy?
Well, I think you have a couple options here. So I know that a number of people said that the Hotmail is the hotline is not very responsive these days. This is a case where I might consider submitting an ombudsman request. Have them help out with issues like this in the past. This is, a seemingly simple procedural error on the part of Vermont Service Center. So you might try an ombudsman request. You can also try, I've seen congressional intervention work as well. I mean, this seems like it should be a relatively easy fix.
I think, Amy, this is one where even though they can't respond to me anymore, the heads of the VAWA unit would still take a look at it because it's purely procedural. So, Lynn, why don't you forward me and Amy the email you sent to the hotline? We'll probably help you organize it a little bit. There's a certain format we like to use, and then I can send that off to the heads of the unit and also headquarters. Okay, so now what's this? Next is Leah. Leah, can we circle back on the checklist for the U visa that includes the I-192? For those who get rejected fee waivers for the I-192 and need money to save up, how long do you think it's okay to delay sending the I-192? Can we continue assuming that if we file 918 packets without the I-192s, these won't even be looked at for over 2 years? Need time to save up money. What do you think, Amy?
Well, it's hard to say. I mean, I don't really think that we can make accurate predictions right now about exactly how USCIS is processing these applications, right? So I don't think that we can make an accurate prediction about, when exactly they're going to be reviewing these packets for initial required evidence as opposed to adjudication. With respect to how long is it okay to delay sending in an I-192, that's also hard to say. It's one of those things where, you would want to submit it as soon as you can, as soon as they've had time to save up the money. The other thing that I would say is that if you think that they were actually wrong in denying the fee waiver, it's perfectly okay, and I would say recommended, to refile the fee waiver application. It could mean that you need to dig up additional evidence as to the person's inability to pay. It could mean that they need a more detailed cover letter specific to the fee waiver, explaining to them, what the requirements are and the evidence that you've provided. It could mean that you need to provide a more detailed explanation if it's a financial hardship-based waiver and you need to provide additional explanation in the little paragraph box. But this is one of those situations where I might recommend refiling the fee waiver in addition to telling the client to try to save up money, but refiling in the meantime to see if you can get it approved. Because they are still getting approved. There are fee waivers that are getting approved.
And also some of them are not. There's some of the denials aren't following their own standards. So Leah, I think you should talk to Amy about this. Send her your emails, and because Amy, you could decide whether the denial was legit or not, and help her figure out what else she might want to supply. So this is that fee waiver webinar that we did for our private membership. Last week or 2 weeks ago? You might want to take a listen to that because there were a bunch of strategies there. Right now we're still working out the right response, but don't assume that they're right because we have seen them deny them using a higher standard than their own guidance says they're supposed to use. All right, so let's see. Kathleen, is it still a good strategy to wait on sending an I-693 medical for you adjustments until you get an RFE so it doesn't expire? In spite of the RFE, or in light of the RFE memo?
So that is a great question. So this question has come up a lot ever since this RFE memo came out. And so here is a situation where I think we have a relatively clear answer. So there are a couple of recent developments on this. The first thing to note is that according to I-485 form instructions, it is explicitly permitted to send in the I-693 medical exam for adjustments, not just U adjustments, after the filing of the 485. And so those form instructions remain in effect, and so it should be completely fine to submit your 693 medical exam for U adjustments after. You can wait until you get an RFE. You can also submit it before that if you want to. This was specifically also addressed in the USCIS stakeholder call a couple weeks ago, and they stated that because it's in the form instructions that this is permitted, that it's going to continue to be permitted. The other very recent development is that USCIS just updated their policy manual about medical exam validity periods. And so for medical exams, for applications for 485s that are submitted after November 1st, as long as the medical exam and the underlying 485 filing are submitted within 60 days of the civil surgeon's signature on the medical exam, the exam is actually going to be valid for 2 years. And at this point, most adjustments are being adjudicated well within 2 years. Hopefully that doesn't change. And so theoretically, even if you file the medical exam at the same time as the adjustment, you should be able to, it should be fine. You shouldn't have to submit a new medical because in theory the adjustment would be adjudicated prior to the expiration.
Just a little footnote, I've been arguing since the beginning that they shouldn't be requiring medical exams for U adjustments because to me they seem to go to inadmissibility. Did they articulate some other rationale for requiring them an adjustment when you've already overcome inadmissibility? Have we heard? Amy?
I haven't heard of another justification for it. I think that if people want to fight that fight, they certainly can, but it's one of those things where you might want to pick your battles, right? And you fight that fight when you actually have to. So.
It's hard to do on an individual level because the responses we used to get were, well, it's in the form. It's like, okay, that's not a very good argument, but what can you do? Catherine says, how long is it typically taking between U visa waitlist approval and interim work authorization?
So I don't know the answer to that one. I'm guessing that the field is going to have much more up-to-date information on processing times. And so if anybody has information about that, please put it into the chat box. Otherwise, that's a question that could be posed to the VAWA experts listserv. I'm sure there are people who have up-to-date information on that kind of processing time.
Good point, and we need to put this on the research slide. We run 2 listservs, which are free, and you'll be talking to everybody who does this work. VAWA Experts is for strategy sharing. VAWA Updates is a one-way communication from us on latest developments and things like that. Okay, Nubia has a couple. What are our options arguments when USCIS tries to revoke the U after the applicant applies for US because upon further review, the 918B had bad language and implied the client wasn't as cooperative as they should have been? You know what? Contact us, Nubia. This like I love challenging them on this stuff. She's also asking, is VSC adjudicating U visas based on orders of protection favorably? Or are they still pushing back that the order of protection alone, rather than filing a police report, isn't cooperation? Oh, okay. My understanding in the past was that the problem wasn't that it wasn't cooperation, it was that it wasn't a criminal investigation. I don't know, Amy, what have you been seeing lately about, I mean, and we've seen them go both ways, to be honest with you on that.
Right. They do go both ways on those, which is, I think, really frustrating for practitioners because it's hard to advise your client well about, what their eligibility is for this case if USCIS comes down both ways on the same facts sometimes. Right. And so they do sometimes push back on this, but they also sometimes do grant them. So this is another kind of situation where if you're getting an RFE, if you're getting some pushback from USCIS on this kind of fact pattern, please send us a TA request and we'll help you walk through it.
And presumably if you're dealing with protection orders, it's a certification from a judge. So I think the key language that the judge has to supply is that he or she has the authority to detect crimes. That's what their own regulations say about judges. So as long as the judge makes that clear, and maybe even if you can help them if they don't know it, cite their authority to detect crimes, even in the civil context, I think that's what gets you over the hump of whether this is a criminal investigation. The helpfulness is a stupid response, to be honest. If that's what they're saying, that's ridiculous. But I do think that the question of whether it's a qualifying certifier is a legitimate question. Laura asked, has a CSIC, oh, I don't know, maybe you know the answer to this. Have we gotten feedback yet, Amy, on the cases we submitted to USCIS about where the fee waivers were wrongly denied using the wrong standard?
Not that I'm aware of. I can follow up with Cecilia, and I'm sure that if we have gotten some response, we'll be, updating the field about it. But to my knowledge, we haven't gotten any feedback yet.
Yeah, I mean, and that's a significant change in the communications with the government that's happening. Is that we are mostly a one direction communicator now. So we may never hear back, but we may see changes because of it, and we're also, exploring other ways to challenge this. As one of the ways we want to challenge this is to help you do it on an individual case level, because I think the more they hear the same problems, the more they get it, and then we raise them to the heads of the unit, and hopefully they have some training on it, because it doesn't look like they've had any training on it yet, as far as we can tell. So that looks like we've run out of questions.
Yeah,
I think we've
great.
And you all know how to reach us if you have more, and tell them more about the next webinar you're going to do, Amy.
Yeah, so as we mentioned at the end of this one, we're going to be covering administrative review. So if you get an RFE, you responded to it, but your case is still denied, what are your next steps, right? So we're going to be walking through motions to reopen, motions to reconsider, administrative appeals to the AAO, and then in the event that all of that fails, what other options do you have? And so I think this is a really exciting opportunity to talk about some other complicated issues that are arising these days, and to see what you guys are all seeing too.
Okay. Well, thank you all very much for participating. We really especially want to thank the folks who chatted with us. It's very helpful to get your actual cases, and for those who are new, to see the kinds of issues you're dealing with. And we cannot stress enough that this is what we're here to do. Amy in particular, this is all she does, is she helps you guys. So contact her with any kind of question, suggestions for training, suggestions for advisories that would be helpful. And we look forward to working with you over the coming year. And thanks to the NCJF gals for helping us make this happen. Okay.
Sorry, a couple people are still typing, so I'm going to let them finish what they're saying, and then we can close out.
Okay, so Viana, you're not going to be able to find it, probably, the YouTube channel, because it's a members only, it's a grantees only channel. So send that email to questions@assisttohelp.org, and that's Maria who will give you the link.